Good morning, Mr. Lucille.
Good morning, Chief Justice Marshall. Thank you. It's Attorney James Rossio from Worcester appearing on behalf of Craig Holliday. I do want to acknowledge, by the way, and thank the clerk's office and my brother counsel for the co-defendant, Attorney Rollins, who did make arrangements, I believe, for an additional 5 minutes for each of us because we're arguing.
You have 15 minutes, so just
All
keep
right,
going.
So I
Don't
acknowledge
draw too much
that.
attention to it because my colleagues will get angry that I give additional time, so just keep going.
Thank you. I'm prepared to address specifically two principal issues that Mr. Holliday has, and that is the custodial interrogation issue, and then also ineffective assistance of counsel. I acknowledge, obviously, the perhaps the most significant issue in this case, and that is the one that stems from the protective order. I do acknowledge the fact that an amicus brief has been filed with the court, and unless the court poses questions to me with respect to the protective order issue, I'm going to just briefly comment that the comments, particularly submitted by the amicus brief, suggesting that this is a structural constitutional aspect to this, is very well presented. And again, I would point out what I say in my brief, and it's, I believe, undisputed that there was absolutely no factual support whatsoever submitted to the trial court at the time that the Commonwealth sought the protective order in the first place. All that was submitted was a memorandum by then ADA Tochka, now Judge Tochka, basically stating, I'd respectfully suggest his opinion as to why a protective order of this nature would be sought. But in fact, there was absolutely no supporting affidavits whatsoever suggesting that a protective order of this nature was called for in this particular case. And that in and of itself, I would respectfully suggest should be dispositive of the issue, and so that the court's consideration of all that was done at the new trial motion with respect to, in effect, a harmless error analysis that, in effect, it really made no difference because the defendants did get everything in one fashion or another, is really irrelevant, I'd respectfully suggest, given the nature of the structural constitution.
Is it irrelevant? How could it be irrelevant if at the end of the day the defendants got everything that they were entitled to?
Assuming for the sake of the argument, Justice Cordy, that they did get everything that they were entitled to, and I respectfully suggest that they didn't in the first place. But the reason I suggest that it would be irrelevant is that given the original nature of the protective order that was completely unsupported by anything at the trial court level, that is a structural defect that renders irrelevant any consideration after the fact in a harmless error context. And I'd respectfully suggest that it's one of those rare situations where you're talking about the structure of the case itself, and if you invite the Commonwealth to submit after the fact evidence as to what would have happened, what in fact happened, then in the absence of any supporting evidence, in the absence of any effort to comply with the relevant statute, General Laws Chapter 258B, then you're effectively inviting the Commonwealth to seek orders of this nature on a concern about this, but without anything to support it. So
let me just, I'm trying to understand how this plays out. If let me use a different analogy. If a defendant requests a reasonable doubt instruction and the judge says, I absolutely refuse to give it, I'm not going to give a reasonable doubt instruction, and the defendant says, I object, I strenuously object, I vehemently object, the judge says, I'm not going to give a reasonable doubt instruction. That's structural error. The judge then gives a reasonable doubt instruction. Is that structural error?
And he has given the instruction? No, that would not be.
So why isn't the same thing apply here? If the judge imposed, an unreasonable restriction or an unconstitutional restriction on discovery that you claim affected the right of the defendant to interact with his lawyer, but in fact, the defendant did get discovery material that allowed him to interact with his lawyer, why isn't the result the same?
The distinction I would respectfully suggest, Your Honor, is in the hypothetical that you suggested on the reasonable doubt instruction, it seems to be beyond dispute that a reasonable doubt instruction was given. In this particular case, we had 5 or 6 days of contested evidence post-verdict at the new trial motion. Was completely, it was disputed, strongly disputed.
But did the judge find that the defendants received, in fact, received the witness statements, and they were allowed to converse with their counsel about the contents of those statements?
Yes, Judge Rouse did so find, and I would invite the court's attention to those portions of my brief in which I.
You dispute it.
In which I suggested it was clear error, and a simple reading of the new trial motion transcripts, and I've cited many instances where it's completely unsupported in many, many respects. There's a lot of inconsistencies. I know that is a very difficult argument to make, that the trial court's findings were clear error, but in this instance, the transcript post-verdict, the new trial motion transcripts, are not at all consistent with Judge Rouse's findings.
Could you help me out with one thing that I'm not sure I understand? Is your argument that even though the defendants had the statements, they were prejudiced by not knowing from whom they came? It wasn't enough to have the body of the statements. They had to know names and addresses. Who made which statement? Makes a difference.
Your question suggests that they did get the statements. That's disputed, by the way, that they did get the statements. That was a disputed factual issue.
But the judge found that they did get the statements.
They did get it in a redacted fashion.
Well, that's it. I'm not sure what was redacted. Is it only names and addresses that were redacted?
The Commonwealth would contend they did it the new trial motion, and again, this is disputed, but that the names and addresses were redacted.
But the statements were not redacted.
But the statements were not. So
you had the statements, you just didn't know from whom they came, based on the judge's findings.
That is what the Commonwealth is suggesting occurred. If you look at the protective order itself, however, the protective order indicated that names and addresses would not be furnished to defense counsel, nor to the defendants or to anyone else, and furthermore, statements and other documents would not be given to the defendant at all.
Right, that was the protective order, but then apparently the assistant district attorney and counsel agreed, and the DA gave over the statements, I gather.
And that is all disputed, Your Honor, and that gets right into the clear error. I contend in my brief, and I do as best I can in my brief, pointing out many, many instances from the new trial transcripts where those findings are clearly erroneous. I know my brother, Attorney Rones, is prepared to speak further to this issue. With the Court's permission, I would like to spend some time on the one issue that is unique to Mr. Holliday, and that is the custodial interrogation issue, if I may, and then briefly comment on the ineffective assistance of counsel with respect to Holliday. So if I might turn the Court's attention to the custodial interrogation issue, there's 3 aspects, 3 areas of concern that I raise here, and that I'm asking the Court to, in asking the Court to consider this issue. The first I respectfully suggest is that the state of the current law in this area in Massachusetts, there appears to be some conflict, and so this is an opportunity for the Court to clear up that conflict within Massachusetts law. And specifically, I direct the Court's attention to your 2004 decision in Commonwealth versus Maxwell, in which this Court basically said that there is no analytical difference between the indictment and the complaint. And that is when the Commonwealth was seeking buccal swab testimony from a person against whom a complaint had been issued from the district court, and it was permitted. So there again, I suggest it's an inherent conflict in our law here in Massachusetts. I would also suggest that the state of the current law, whether or not the right to counsel vests when that complaint issues from the district court, whether or not that then becomes a critical stage of the proceedings, that there is an inherent conflict between the federal authorities and our state law on that, and I cite Gouveia, Fellers, and Kirby, all Supreme Court cases, and specifically from Kirby, that the right to counsel, a Sixth Amendment right to counsel, vests at the time that you initiate adversary judicial proceedings. And I respectfully suggest that the issuing a criminal complaint from a district court, albeit by a clerk magistrate, is clearly an initiation of adversary judicial proceedings. Trying to understand Smallwood and how that can still be, short of overturning Smallwood, I think that this court can say what Smallwood says is that when a police officer goes into the district court seeking a criminal complaint, even for murder, at that point there is not a right to counsel. And I think that that's, I don't think there's any argument there. But then once the complaint has issued, and now the police officers, the detectives are then proceed armed with arrest warrants and criminal complaints, then at that point they go beyond mere investigation, and then we now need to be concerned about the Sixth Amendment aspects of a targeted defendant's his Sixth Amendment rights to counsel. In this particular case, what happened, and this distinguishes from Torres. In Torres, he had been indicted when he was questioned. In this case, and furthermore, in Torres, this court acknowledged, the SJC acknowledged that the police officers had gone to interview Mr. Torres, had gone to see Mr. Torres just to serve the arrest warrant. In this particular case, it's beyond dispute that the two Boston police detectives went out to the Concord State Prison, if not exclusively, at least primarily for the purpose of interviewing Mr. Holliday. So that's what they were going there for. I had another thought if I just...
They didn't need the complaint to go interview him, did they?
Excuse me?
They didn't need the complaint to go
No, they
interview
didn't. That begs the question, why did they get it in the first place? Basically what they did was they went out and they did Mirandize him immediately. Now, he is in prison on totally unrelated matters, and they did Mirandize him. He signed a Miranda waiver, but on 2 or 3 instances during that interview, and this is beyond dispute, he said, "What is this about? What is this about?" And then well into the interview process, I think before they actually started the tape recording, he then poses a question, "Am I being charged here?" And then at that point, after he had already given some pretty significant inculpatory or that he had been at the affair that evening and so forth, then they say yes, and they show him the arrest warrant. And so what I'm suggesting, by the way, and I'll ask leave of court on this point, I have been in the process of preparing a reply memorandum, which would have been timely but I haven't had an occasion to complete it. I specifically wanted to address the Article 12 aspects of the custodial interrogation concerns here, and specifically in the wake of Commonwealth versus Murphy, in which this court said that an inmate is in effect an agent of the law enforcement, allowed to go into the general population, and this court said, well, that is just not going to be permitted, that the people subject to that kind of, would have been Mr. Murphy, that you just can't do that. That completely flies in the face of his Sixth Amendment, and specifically Article 12, rights to counsel. I argue that in the wake of Murphy, it's relevant here as well, because, and the key point, I think, that distinguishes it from is the unsuspecting nature of the questioning. In Holliday's case, there was no question he knew he was being interviewed by law enforcement. No question about that, even when they Mirandized him. They clearly identified themselves as Boston police detectives, but he had no idea whatsoever what he was being questioned about, and he asked repeatedly for that.
Mr. Lucille, thank you, but your time really is
Oh,
up.
that's right there, okay. And I'll submit on my brief on the other points. Thank you, Your Honor.
Thank you. I didn't, Mr. Lucille, are you going to file a reply brief? Is that what you were doing?
I'd ask leave of court. We're still within the 30 days. The Commonwealth only filed their appellee's brief within the last 3 weeks or so. So I think I still have time, but obviously we're here for oral argument. But
Well, why don't you file a motion if you, so we can sort it out?
I
Thank
will.
you.
Thank you, Your Honor.
Thank you, Mr. Lucille. Mr. Clones?
Chief Justice Marshall, members of the court, we have two individuals here, and we have to look at each one because the lawyers at the trial testified in different ways as to what was received by their clients. And another point, assuming Judge Rouse's findings as fact, you have blatant violations of the most important right, the counsel and his lawyer preparing for trial. There's no question that my client only got the redacted statements, and I'm talking about redacted statements, only actually got them in his own hands on the eve of trial. How can you possibly effectively help your lawyer if you don't have the names of the witnesses making a statement?
Did the attorneys have the statements beforehand?
The attorneys had the statements.
Okay, so there was, even with the order, you could tell your clients what was said
Oh, yes, but
orally.
yes, but if you've been in a trial mode, you go over these statements. Prisoners help out. They take copious notes. You need to have those statements in front of you to work on them. To have a lawyer come down and just read the statement without giving the name isn't very helpful.
Well, could you write, were you, under the order, were you permitted to write them out for your client?
Write out what?
The statement?
No, that's the whole purpose.
You could tell them, you could tell the statement to him orally, but you couldn't write it out.
Yeah, that's right.
You could write, could you write it out? I mean, they didn't want it published around the prison, I understand that, or the jail, in its form, but were you prevented from writing it out in longhand yourself under the order? That's what I'm
And
asking.
give it to the
Yes.
defendant? Oh, sure. That
Okay.
would be the same thing.
Well,
Okay.
I mean, the order is very, it's very, I had it a minute ago.
Oh, yeah.
Here we go. I order that the addresses and locations of the witnesses not be disclosed to defense counsel or the defendants, right? I further order that defense counsel not be given written copies of transcribed witness statements, reports containing witness statements, and so on and so forth. And I order counsel to make available witnesses for defense counsel in order that defense counsel may request interviews. Am I reading it correctly? Yeah. This is Judge Voltaire's.
This is an unbelievable protective
Well, what
order.
I'm saying to you is then I hear that somehow you got redacted statements. Counsel,
in a violation of the court order.
Yeah.
And no one went back to the court. So they violated the court order. But that's, I mean, assuming they did that, they shouldn't have done it. The fact they got redacted statements doesn't mean anything.
They were redacted only as to names and addresses.
Yes, but they didn't give them the statements to work with, and that's important.
No.
To read a statement without the name and take them home, how can the client in any way
Well, the order
effectively help you?
The order doesn't say names, it just says addresses and locations.
Actually, that's correct.
Oh, everyone interpreted it as names. Everyone
That's not what
across
it
the board.
says.
But that's what they interpreted it as. This was even broader. You weren't supposed to give even the statements, let alone the names.
But the order didn't prohibit the prosecutor from furnishing the statements to defense counsel.
No, but that's not the point in this argument.
I know. I understand what you're saying. But defense counsel, at least under the terms of the order, was entitled to receive a written copy of the witness statement.
Oh, certainly. Okay. The whole issue in this case is, and it's a very important issue, we will assume, a client, a defendant has a right under the Sixth Amendment to work with his lawyer in an effective way to prepare for trial. My client saw the unredacted statements in the middle of trial, at the beginning of trial. He could have, if he had the whole thing, give suggestions to the lawyer as to what impeachment should be, what should be further investigation. And because it's such a right, there has to be specific and articulable basis, as we have in the grand jury statute. If you're going to take away this right, then you have to have a hearing where there's cross-examination. That's only reasonable. You have concerns for the witnesses, and that can be taken care of in the Witness Protection Act. There are other ways to do it. But even if you say a protective order we're going to allow under certain circumstances, how can you not say that the defendant has a right to challenge whether or not, in fact, there are threats?
Mr. Rones, could you just clarify for me what happened here in terms of the protective order? The judge issued the protective order, but then as I read it, the DA and defense counsel had this side deal where...
At one counsel, so you've got to look at both guys separately.
All right. Just, give me the big picture.
His client, his lawyer claims that he turned over the statements unredacted in blatant violation of the order.
Who? The other defendant?
The other defendant's lawyer. My lawyer said no. And there's a very interesting letter. You'll see it. She sends a letter to him saying, "Please do not ask me to send you witness statements or names or addresses of any witness. I am ordered by the court not to give them to you."
So the co-defendant had the statements?
Well, there is something in the record to suggest he did. I mean, much more than in my case. My case, there's no evidence that he ever got the unredacted statements until trial. And he only got the redacted statements on the eve of trial.
Do we know why the DA gave co-counsel the full statements and nothing until the eve of trial to your client?
Oh, he gave the same thing to both, but it was the lawyer that gave it to his client. Now, I might point out that you can't prove prejudice in this case. If you say, there's no prejudice. You can't prove prejudice. It's like the Downey case. How are you possibly going to quantify or what didn't go on that would have gone on? You'd be invading the attorney-client privilege. I shouldn't be required to show prejudice by indicating what my client would have told me that would have helped me. There might be a retrial. So it's important to read the federal case, the Supreme Court of the United States case in this regard. U.S. versus Gonzalez-Lopez, 2006, Scalia. And he talks about structural error. Structural error is a situation where some of the error is outside of the actual trial process. Most of the error in this case was outside of the trial process. It isn't your normal type of case where you have trial error. And when you have structural error, it's a situation where you don't have to prove prejudice because you can't prove prejudice. They cite this case was where he had a right to his own counsel of choice. And the court says, well, how do you know whether or not he didn't get a fair trial through the other counsel that wasn't his own choice? And the court said, well, you can't, so that's not satisfactory. Just because he maybe got a fair trial doesn't mean it. Anything in that context. Of course, in our case, we argue there was no fair trial.
Mr. Clarence, can I just ask you a question? On page 23 of Ms. Lovell's brief, she says the order was properly entered. I'm not worried about that. And because both defendants, not their counsel, both defendants had access to the discovery material well before the start of trial.
No, that's not true. In fact, I think even she concedes that it was eve of trial. The lawyer said, I don't know when I gave it to him. It could have been eve of trial. And in her brief, she points that out. So how can he possibly assist his lawyer when he's getting the unredacted copies in the beginning of the trial? But the Superior Court now is in disarray over this issue. There are no standards. I suggest to the court they've got to be given some guidance. You have the statute dealing with grand jury minutes, and that's exactly the type of thing you need, where you acquire specific evidence of threats. In this case, it was just a broad thing. Because you're supposed to be a gang person, we're going to restrict your rights.
Could I ask you this, Mr. Clarence? It's interesting because until Justice Spina pointed out, I've read the briefs, I've read the protective order, and I just automatically read names, addresses, and it isn't. Would you have a difficulty if the addresses and locations were redacted?
If what was redacted?
The addresses. In other words, you have witness statements. Presumably you had the witness name, which the judge did not order redacted or not disclosed. But both defense counsel and the defendants were not to be given the addresses and locations of the witnesses.
Well, why I didn't touch on that is there's a lot of case law that you don't have to give the addresses.
Correct.
So I
don't have
pulled away from that. The argument
I
of
just
the
want to clarify, so you
yes,
don't...
I think they should have, but I'm pulling away from that because of all the case law. And my sister, in all her precedents relative to this issue, cites situations where the defendant wasn't given the addresses. And there you're talking about
safety of witnesses.
Right, in a more specific way. But even that can be challenged under this analysis. If you don't have the addresses...
What are we to do if everybody misinterpreted the judge's order and the judge's order permitted the names to be disclosed? And if the judge's order permitted the names to be disclosed and the DA didn't give you the names, you could have gone back to court to enforce the order, to get the names.
No, they went to the single justice, to Judge Abrams, and she said, look, I'm not going to do anything. There's an order. You can appeal after trial.
But if the order only prohibits the disclosure of the addresses...
Well, it didn't.
Well, Justice Spina just read it to you.
No, it prevented giving the statements or the names of the witnesses.
No, the order says you cannot give the defendant the addresses, locations, or copies of the statement. Mm-hmm. And I take it what Holliday's trial counsel and the assistant district attorney did was agree between themselves that give them a copy of the statement, but cross out the name as well. Isn't that what they agreed to?
Maybe they did.
That's what I'm saying.
My counsel didn't.
I'm saying Holliday's counsel, trial counsel,
yeah.
and the assistant district attorney entered into a side agreement where the statements could be furnished to Holliday, but the names would have to be deleted.
But the whole point is if the names are crossed out, the statements are worthless.
I'm just asking you, is that the arrangement that was made?
Yes, as things evolved, apparently the agreement was you could read the statement without the names to your client. You couldn't give him the statement.
Yeah.
So it was modified to that effect. But that isn't very helpful in terms of...
But but your client, who you say didn't get the names of the witnesses, could you have gone back to court, given the wording of the order, and asked the judge to enforce the order to the extent that you be given the names of the witnesses?
Well, there's no way he would have done that, because that's the whole point.
But the order
They don't
didn't-
want the names of the witnesses out. That's their bottom line.
How do we know that? If the order says only addresses, how do we know they didn't want the names? Maybe it was just addresses.
It doesn't say address. It says not to give written copies of transcribed witness statements, reports containing witness statements, or witness statements from the defendants. Well, if you don't give the witness statement, you're not giving the name.
Mr. Clance, I understand your argument. I'm trying to figure out factually. Did your client's counsel receive copies of the written transcripts of transcribed witness statements, reports containing witness statements, or witness statements in any form,
Oh, yes.
with the names?
Oh, yes. The counsel received everything.
But you didn't get the addresses.
No, you got
Well,
everything.
they aren't on the statements. I think he probably got the addresses, but, I mean, we're not really dealing with that issue, with the addresses, so to speak. The point is that these other things were implemented in terms of not being able to read the statements or effectively use them. Now, one other point, there's another very important issue in this case, and that is the incompetency of counsel in the failure to call to trial or even investigate two key witnesses. One of the witnesses said another guy was shot outside of the home, and that that guy that was shot had been in the home, that he had a gun the day before. It was the same type of gun as used in the shooting. There was another witness, a woman, who said, I saw someone get shot, and he was on the ground, and he said, get rid of that gun. Now, any way you cut it, that would be tremendously advantageous to my client, who's saying, I didn't do it, as opposed to, I did it in self-defense. So that's another very troublesome issue.
Thank you, Mr. Clance.
Thank you.
Ms. Lovell?
Thank you, Your Honors. Good morning. Amanda Lovell for the Commonwealth. May it please the Court, I'd like to start with clarifying the factual basis around the protective order. And the first point is, as Judge Rouse found, there's no question that both defendants knew who was making statements against them and what those statements were.
No,
When?
As to Holliday, it was essentially immediately, right from 96. And I'm not sure that she makes that finding that specifically, but it's very early on. As to Moultrie, she says...
Wait a minute, I'd like to answer to the rest. And as to Moultrie, when?
As to Moultrie, she says between January 98th and before the eve of trial. That's at page 16 of my appendix.
The trial was in May of '98?
Yes.
Ms. Lovell, it would be very helpful to me if you could tell me whether they had the written statements or you're just saying they had the information.
I'd be happy to explain that, Your Honor.
Counsel, I take it, counsel for both defendants were given all of the witness statements.
That's correct.
With nothing redacted.
The only thing that counsel did not receive at the beginning of the case were addresses or locations of witnesses. But they did receive all of the witness statements with the names of the witnesses, none of that redacted. What happened, essentially the testimony at the motion for new trial hearing, which was spread out over 5 days, there was extensive evidence taken on this case. Attorney Curtis, who represented Holliday, spoke to then Attorney Tochka immediately after the first hearing, which was on, I believe, October 28th. And at that time, the motion that the Commonwealth filed referred to, among other things, that redacted witness statements. Attorney Curtis went to Attorney Tochka and said, so if I take the statements and redact the names out, I can give them to my client, right? And according to Attorney Curtis's testimony, Attorney Tochka said, yes, my concern is that they not have tangible copies. And I'm paraphrasing here. But that what happens is that...
Well, they'll still have tangible copies. They just will have
With the
copies
da-
without the name.
with the names in them, correct?
No, but he was
because-
not going to leave copies with his client, correct?
No. What according to Attorney Curtis's testimony, his understanding was that Mr. Holliday could have the copies as long as they did not have the names in them. And the reason for that, and this is well explained, argued at both the October 28th and the November 6th hearings before Judge Volterra, where Attorney Tochka said, what happens is people have grand jury minutes or witness statements. Defendants get them, they make copies. They pass them around the prisons, or they pass them around outside the prisons, and then people go up and confront the witnesses. And this has one of the witnesses' names right on the front of it. It's a police statement from Tyrone Dickerson. People go up to Tyrone Dickerson and say, look what you said to the police. This is grand jury testimony from Alistair Hill, who testified. People go up to Alistair Hill and say, look, you testified at the grand jury. And then witnesses are intimidated from continuing in the investigation or coming forward. So that was his concern, and it's very clear from the transcript of both hearings before Judge Volterra that what Attorney Tochka did not want to have happen was to have copies in the hands of the defendants which actually had the names of the people who were making the statements, so that the defendants could use them in that manner.
Okay, so then as to Holliday, anyway, Holliday himself got the statements without the names, without the witness's name.
That's correct.
Okay, and what happened with the other?
With Moultrie, the same thing happened, but at a later time. Attorney James did not have, essentially, and one of the members of the court asked why Attorney Tochka made this arrangement with Holliday's attorney and not Moultrie's attorney. Essentially, it was when each of the attorneys approached Attorney Tochka. Attorney Curtis did it before the second hearing. He did it, according to his testimony, on October 28th, immediately after that first hearing before Judge Volterra. Attorney James testified that it was after she received the letter in January of 1998, to which Attorney Rones referred, that she went to Judge Tochka and then Attorney Tochka. Her testimony was that Attorney Tochka said that by that time enough time had passed, the concern was decreased, and yes, she could redact the names out and give the witness statements with names redacted, and that she did that.
Mr. Clone said there should be some kind of hearing, that there were specific threats. What was the nature of the hearing, or the two that led to the entry of the protective order by Judge Volterra?
It was an argument. What was presented was a memorandum with a statement of facts where the concerns that the witnesses' concerns were laid out, and Attorney Tochka also expressed what those concerns were. There was no request at that time for an evidentiary hearing. Attorney Curtis did mention that there was no affidavit, but his forceful argument was not the lack of a factual basis. The forceful argument was, I won't be able to represent my clients if you issue this order.
When was trial?
May of 1998.
And you say sometime after January, but we don't know any more specifically when?
Well, Judge Rouse found sometime after January, but not at the eve of trial.
Okay.
But I take it that that Moultrie's counsel was authorized he was given the same deal as Holliday's counsel was given with respect to turning over the papers, copies of the papers with names redacted, some point in January of 1999.
98, yes.
98.
That's right. Yes.
When
And
the transfer actually occurred is unknown.
that's correct, although I would argue there are two reasons why the inference that it happened almost immediately and therefore in January 98 is a strong inference. The first inference is that Attorney James was very anxious to get this material to her client. She was, well, both of the attorneys were very zealous advocates on behalf of their clients, but she obviously chafed under her perceived inability to give the information over, and she still testified about, she was still chafing about it, frankly, when she testified at the motion for a new trial. So it's unreasonable to think that being given this permission after having received letters from her client saying, I want these statements, and writing back and saying, please stop asking me, I can't give it to you, upon believing that it was all right for her to give them, that she would not have turned them over immediately.
I didn't follow that. That she would not have turned them over to whom?
The client.
To her client. She so wanted to.
That once she got them,
Once she was given permission. She always had the statements. Once she was told that it was okay to turn them over. I would argue it's the inference is that she did so immediately. I
think it would be very helpful if there is a protective order, if the Commonwealth decides that it doesn't need the protective order, doesn't need the full scope of the protective order, to get a modified protective order. Otherwise, you get an ethical attorney who's trying to comply with a court order. It suggests that maybe the scope of the order was too broad to begin with.
Agreed, Your Honor. And this was the first time that the Suffolk County District Attorney's Office had proposed an order like this, at least in recent history. And we've learned a great deal in the last 11 years since this order was drafted.
So what do you look for now?
What was the second reason? You said there
Yes.
was another reason that the inference was it occurred immediately.
Thank you, yes. And that is, as Judge Rouse found, that after that January 11th letter, to which Mr. Rounds referred to Attorney James's response, there were no more letters from Mr. Moultrie saying, give me the statements. Now, also in evidence at the motion for new trial.
Let me back up for a second. So what does the District Attorney's Office do now, having had 11 years' experience? What?
I believe that Your Honors actually have had the opportunity to view one of the protective orders in a recent case, Ray v. Commonwealth, which is at a pretrial stage. I believe that it actually spells out in the order that, as I'm recalling the order, that attorneys can go back before the judge to seek modifications. I think that was understood in this case, and yet obviously it didn't happen in a formal manner. I think that the attorneys in this case were all experienced attorneys who were used to dealing with one another and essentially trusted one another. And so I would say that what happened in those two conversations was seen by the attorneys not as a modification of the order so much as a clarification of the order. And so...
Well, it was seen by one, but not the other, apparently.
Apparently, yes. That's fair to say.
And what would be the basis of seeking a modification?
The issue that as trial approaches, more information is needed in order to prepare for trial.
But the assumption behind that is that an attorney doesn't do anything until you get to the eve of trial. And then, the whole point about why we, I don't want to say tolerate delays, but why we don't go to trial the next day, which people used to do, was so that you would give the attorney representing the defendant, and in some cases the Commonwealth, an opportunity to prepare for trial.
Well, and in this case, Your Honor, as the judge found, both of the defendants knew, even before, actually stepping back a moment, even before Attorney James gave Mr. Moultrie the copies, the redacted copies of the statements, she had read them to him. She had omitted the names when she read them to him, but she had read them to him and discussed those those statements, and it was clear to her that he knew who the statements were coming from. Now, this is a case where...
If the point is that you don't want copies made and distributed in the community, aren't there other ways to secure that?
Yes, Your Honor, and the order could have been better drafted, and as is
What are
in
the
the
other
record-
ways of securing it?
Well, I would say if the order specifically said defendants may only have copies of statements from which all witness names had been redacted, that...
Isn't that what it said? Well, no, it said, it didn't even say redact the names. I don't understand. Why is that another way? That's just...
Because the problem isn't the content of the statements, the problem is having...
names, I understand.
Yes.
But the names...
Well, it's the problem is having names on the tangible copies.
Then don't you have an order that says that you can tell the defendant what the name is, but the copy that you give to the defendant?
Cannot have the names on them, yes.
Is there
That
any
seems
way
to
to
me-
prevent copying?
Well, the copying problem is the copies with the names on them.
No,
But
I
that
understand.
seems a very, really no difference. Anybody can write the person's name on it once they know who it is and go up to that person and wave it in their face if that's the issue.
But that doesn't have the imprimatur of the Commonwealth on it. Anyone can go up and accuse somebody of making
No,
a
but if you
statement,
have the same thing and
The
everybody
same effect.
knows.
Who knows whose handwriting it is? Maybe it was the DA's handwriting. If the witness's name is on it, nobody knows who put it there.
well, except that, again, the witness statement, the grand jury minutes, it's typed in saying who the witness is. And that
I
he's
can't
under
believe
order.
if you're a witness and you know that you testified before the grand jury and somebody comes up with a copy of your testimony and it just doesn't happen to have your name on the front, and that person knows, and you know that that person knows whether or not it actually has the name on the front. I mean, it seems to me that this is a very cumbersome mechanism to address a legitimate concern, but that doesn't really address the concern and may impact on the defendant's right to prepare for trial.
Well, there is, of course, the statute now that was enacted in 2004 that makes it a crime to
Essentially to
knowingly
intimidate,
distribute
yeah.
or possess with intent to distribute grand jury testimony.
And what is the penalty for that?
Up to 5 years in prison.
And when somebody is facing life in prison without parole,
Well,
is that really a deterrent?
Well, it's not them, it's somebody acting on their behalf.
It could be
presumably.
either, yes.
I mean, that presumably in most of these cases, the defendant is incarcerated, so it's somebody else out there.
well, to some extent, it's the combination of because some of the witnesses in this case in particular were also incarcerated, and that's going to be the case often in gang cases. And I suppose the difference is that I'd certainly. I would certainly rather have somebody come up and say, we know this is your statement, than to have something that is typed in and clearly my statement and much harder for me to deny.
If the first question that they'll probably maybe how old are you, where do you live, if the identifying information is all in there, even if the witness's name isn't typed on the front page.
Well, then certainly I would say, I would add that name and identifying information. If there's a date of birth, if there's a very specific address, it could be redacted to
Well,
a
even the content of the
neighborhood.
statement itself, you take out all the names and addresses and all
Yes.
the dates of birth and all that, and all of a sudden you got a statement in there that says, he told, the defendant told me and my girlfriend, Susie Jones, that you're going to end up, you have to do an awful lot of redacting.
And that's actually quite relevant to the statements that the witness statements that Moultrie ended up with, because in fact we had those. They were admitted as an exhibit at the motion for new trial, and the redactions were incomplete in them. And it's very clear, one can easily go through them, as Judge Rouse found, and figure out who those statements are from.
But that's my point.
Yes. Well,
It seems to be a very cumbersome procedure to achieve an objective which it doesn't achieve and impacts on the defendant's right to get the information.
I'm It's a fair question, certainly, Your Honor. I would say that that in this case, as well as what the legislature was thinking in, I think when it enacted its law, it's an attempt to balance the witness safety with the defendant's rights. And certainly, the defendant's rights in this case were not forgotten by the Commonwealth, and I think the clear understanding was that if you reach a point where you're not able to go forward with the information you have, and that's the difference between having nothing and just not having the written copies. If there's a point where this just isn't working, then go back to the judge and figure something else out. I would bring the court's attention to regarding Moultrie's claim that about not knowing the information, that at the hearing on the 211-3 petition, Attorney James specifically talked about that it would be very cumbersome for her to have to go out and read the transcripts to her, or read all the statements to her client, and that it would just take a great deal of time and not be helpful to her representation. So it's clear that even at that point, she has in mind that she's giving the information verbally, but that the defendant is knowing the content of the statements.
But the defendants aren't claiming that that their clients didn't know the content. They're claiming that their clients couldn't help them prepare because they had to see the statements and have time to mull them over and look them over, and they needed written statements in order to do that. That's the claim.
I've heard different claims, Your Honor, so if that's the way you understand it.
That's what they said this morning.
I thought they were saying they needed to know who the source of the statements.
I have heard that claim as well, Justice Ireland, and that's what I'm addressing, that that Judge Rouse found that clearly they did know the source of the statements.
They being the defendants?
The defendants,
Okay.
Each defendant. And that's in her findings and rulings, that both of the attorneys were convinced well before trial that that each of the defendants knew who the witnesses were against them and who had made the statements.
Well, thinking about the principle, if we say somehow that what happened here was all right, and according to your argument, it would be that it was all right because they did get the names of the witnesses. So in other words, you're essentially conceding they need the names of the witnesses.
At some point before trial, certainly the defendant would need the names of the witnesses.
Well,
yes.
the judge didn't prohibit him from getting the names of the witnesses.
I agree. The judge prohibited them from getting the names of the witnesses written on the unwritten transcripts.
So you're conceding that the names of witnesses are essential at some point before trial.
Yes, I would say that it would be a very rare case where.
But then
that
you get back
wouldn't be.
to Chief Justice Marshall's question. You can't suggest that they don't need it long before trial because you can't be investigating the last week before trial.
And that goes back to Attorney Curtis's understanding of the order, which was that he could immediately give redacted statements to the defendants and then have conversations with the defendant, with his client. About whether or not he
redacted
knew.
with the names missing.
That's right.
But you just said they do need the names. And they need it
yes.
sometime before trial so
Yes,
they can investigate.
But they don't need the names written on the witness
You
statements.
make a big difference of whether it's written or not, but okay. So you don't.
I mean, I would draw your attention back to the what was presented to Judge Volterra, both through the memorandum that was filed and also the two hearings in 1996 where Assistant District Attorney Toshka talked about the problem being people being confronted with the statements with their names in them. Whether there's a better remedy than that, Your Honor, there may well be, but in this case, that was the concern that was driving this protective order.
Thank you, Ms. Lovell.
Thank you. I would rest on my brief as to the third-party culprit and the other issues.
Okay.
Thank you.
Thank you.